welcome to a new podcast episode of the China IP SME Help Desk. My name is Alessandra Capriglia, and today I will be discussing with our IP business advisor, Matthias Zubimendi, about the most important changes of China's patent law. Hello, Matthias.
Hi, everyone.
Let's first briefly refresh our knowledge. There are three different types of patents in China, namely design patents, invention patents, and utility model. Starting from the design patent, what does it protect?
A design patent provides exclusive use of the aesthetic features of a product. So how the product looks as opposed to how the product functions. For example, a design patent could protect the external appearance of a smartphone, but not the mechanical which allows it to function. It differs from European design rights, as in China, design must be absolutely novel to be patentable. Europe, on the other hand, grants protection to unregistered community designs for 3 years.
Let's focus now on invention patents and utility models. Utility models are very popular in China and unfortunately often overlooked by European SMEs. Can you tell us the difference between the two and what is the so-called dual filing strategy?
An invention patent is granted for new technical solutions or improvements to a product or process, provided that the technical solutions have a practical applicability. An invention patent must be novel, meaning that it must not have been previously published overseas or in China. Utility model patents are very similar to invention patents. However, utility models only protect products with a new shape or structural physical features. You cannot use utility models to protect your business processes. Utility models are easy to be obtained and very useful in cases where an invention may not meet the standards of an invention patent. They may also be preferred to protect inventions with short life cycle, such as ICT products or electronics. Utility models are only subject to a simple formal examination of the application before being approved. This means that utility models are granted more quickly, but the term of protection is shorter. The so-called dual filing strategy is still a common practice under the Chinese IP system. It is about the parallel filing of a utility model and an invention patent, followed by the abandonment of the utility models once the invention patent is officially granted. This way, the applicant can benefit from the early patent protection granted by the utility model, as well as the longer-term protection granted by the invention patent, once it is eventually approved. However, according to the draft revision to the Chinese Patent Examination Guidelines, the CNIPA, the China National Intellectual Property Administration, can delay the examination of an invention patent for 4 years in case of parallel filing of the corresponding utility model. Therefore, companies should be careful when considering this strategy. Factors such as the nature of an improvement, the lifespan of a product, and the chances of the product being copied have to be analyzed.
Regarding today's topic, on 1st June 2021, amendments to the China's patent law came into force. The law underwent substantial changes, keeping up with technological developments and further strengthening the enforcement of patent rights. Let's talk about damages. To strengthen the protection of IP rights holders, the new patent law increased the statutory damages. How do you define statutory damages, and what are the implications of this amendment?
Statutory damages are damages that can be awarded by a judge to a patent owner in an infringement case. They are called such because the range of damages is determined by the statute, such as the patent law. Statutory limitations on patent damages have been a discouraging factor for patent owners when it comes to enforcing one's patent's right. The increase in statutory damages is expected to encourage companies to enforce their rights more actively. For example, if someone infringes your patent, the Chinese courts now have to at least award you with the amount of 30,000 renminbi, which is about 4,000 euros, because the patent law says so. They cannot award you more than 5 million renminbi, which is around 560,000 euros, and is the new upper limit set by the law.
The new patent law also introduced punitive damages in cases of intentional patent infringement. So when the infringer knows that you have patented this invention, but they ignore it and copy your invention anyway to make some money, what has changed?
Courts can now increase by 5 times the estimated damages. This should discourage future intentional patent infringement as it significantly increases the cost of infringing the law.
Moving on, the law aims at facilitating evidence collection. Can you explain how?
In order to facilitate evidence collection and offer benefits to patent holders, the amended patent law allows the court to order the defendant, so the infringing party, to provide financial information about the gains made from the infringement, allowing courts to award actual damages in excess to statutory damages. This is good news for European SMEs, as it means that the evidence they need to provide to the Chinese court is not as extensive. It can be very difficult to obtain all the evidence, especially if you are not in the same country.
The patent law introduced new concepts and mechanisms to encourage innovation. One of these new mechanisms is called the patent linkage system, which is particularly relevant for the pharmaceutical industry. What does this system entail?
The system provides for an early dispute resolution mechanism for pharmaceutical patent disputes involving generic drugs under market approval. The system enables a patent owner of a pharmaceutical patent to file a declaratory judgment while the generic is going through the regulatory approval process with the China Food and Drug Administration. The declaratory judgment action may potentially suspend the regulatory approval process of the generic in case the generic drug is infringing the patent. In short, this system protects the legal rights of pharmaceutical patent holders, encourages innovations in the field of pharmaceuticals, but also promotes the development of generic drugs, as potential disputes are solved in an orderly and predictable manner.
That's a very important news for European pharma companies. Another new concept introduced by the law is the open license system, a method in which a patent owner agrees to voluntarily license the patent rights to any entity or individual for a standardized payment of license fees. In exchange, the annual patent fee paid by the patent owner can be reduced or exempted. What does it mean in practical terms?
In practice, any company or individual who finds your royalty prices and other conditions fair and is willing to produce your product can simply notify you in writing and pay the license fee in accordance with the announced method and standard for the license fee to obtain a patent license. It saves you the trouble of having to find a licensee by yourself, as well as going through the negotiations process. It is of course possible for a patent owner to withdraw the open license statement if they no longer wish to use the open license system. However, the withdrawal cannot affect licenses which were already granted. In general, this system can be a particularly good option for startups unable to find investors who could take over patent annuity fees.
That's indeed a very interesting opportunity. Another good amendment of the patent law is the patent term extension. What is it about?
Under the new patent law, the patent right holder can request compensation for unreasonable delays that were not caused by the patent applicant if the patent application takes more than 4 years to grant the patent. This amendment is beneficial to innovators because it can sometimes take up to 6 years for obtaining patent rights in China, meaning that you will lose 2 of those valuable years that you could have used to explore your patent. Now, in these cases, you could be compensated.
Last but definitely not least, let's talk specifically about design patents, for which one of the most important changes has been made. To begin with, can you tell us about the design patent extension?
The design patent term will be extended from 10 years to 15 years, allowing designers to enjoy 5 more years of exclusive rights to their designs. The term extension prepares China to access to the Hague system which allows to register your designs in multiple countries by submitting only one international design patent application. The exact timeline when the Hague system will become available in China is unfortunately not known yet.
Another important change concerning design patents is the fact that China now allows partial designs. What does that mean?
Allowing partial designs will facilitate design protection for graphic user interface and OEM, original equipment manufacturing sectors. For example, if you design an app which could run on a smartphone, tablet, PC, smartwatch, and other devices, you can now submit just one patent application for your graphic user interface, and you don't have to include the device to which the GUI will be attached. It used to be the case that you have to submit separate application for each device, including the device in each application.
Okay, that's all for today's episode. Thank you, Matthias, for helping us understand more about the new patent law.
My pleasure. If any European entrepreneur has any patent-related question as well as any IP-related inquiry, welcome to contact us via our inquiry helpline at question@china-iprhelpdesk.eu. You will receive a free and confidential reply within 3 working days.
If you want to know more about patent protection in China, such as differences between invention patents, utility models, and design patents, as well as software protection, application fees, enforcement, and so on, click on the link in the description and download our IP guide free of charge. That's all for now. Thank you for listening and stay tuned for our next episode.